Good afternoon. Not legal advice. Like, share, subscribe. Do all of those. Get the word out. Do it for me. Do me a favor and just get people to subscribe to the channel. I've mentioned this before, but for every 1,000 subscribers, I will donate $50 to the LA Children's Hospital, and we're close to a round number. So, like, subscribe, etc. Today's video is an update about MMTLP litigation and related. And part of why I'm doing this and part of my mission statement is to try to make this stuff more understandable so that if any of you are in future legal entanglements, that you'll be better prepared to handle those and it'll make it understandable. Now, the joke about this is I have been trying to make a video for about 2.5 weeks now about FINRA arbitration. So, but before the FOIA response, which was dated March 30th, I had already drafted a video and was gonna put it up. But then the FOIA response came out and everything else. So talking about a FINRA arbitration seemed funny and inappropriate. But I will get back to it, and you will see. Before this, I was concerned about the legitimacy of FINRA arbitration. So now you can imagine how I think. So let's move on to MMTLP litigation and your up-to-date recap. So brief recap. I filed in state court versus Fidelity. I added FINRA and the DTCC. They moved it to federal court as was their right. I amended the complaint further, and that occurred long before March 16th, 2022. All three of the defendants individually filed motions to dismiss, which are procedural motions in attempt to get the case dismissed. And Fidelity also filed a motion to compel arbitration because there's a contract that I have with Fidelity, and even though I claim it's not within the confines of the arbitration agreement, they differ with me, and many courts have differed with me, but we'll see how that plays out. Absent a resolution of our matter, and doesn't make a difference how these motions turn out, I'm going to continue to pursue any and all relief, including any appeals. And if I end up in arbitration, we will arbitrate this, and you'll know exactly what's going on. And I hope to have members of the community there also to be witnesses to the events. But we're not there yet. But just letting you know the progress and what I intend to do. So this is just part of the process. So the motions to dismiss were filed, and then and they were filed, I believe, on March 15th. Ironically, March 16th, I call it the FUQ, but I think they called it the FAQ. I'll let you figure that one out. Was published, and then the 3/30/23 FOIA reply, which I think I saw on April 1, was also published, and that occurred obviously after all defendants had filed their motions to dismiss. Now, prior to even seeing the FOIA release and prior to the motions to dismiss being filed, I had already asked for the blue sheets. Luckily, I did. Ironically, I had asked for the blue sheets of all defendants, and it's on record. I'd asked for discovery. I'd propounded discovery in the state court. But technically, if it theoretically wasn't stonewalling, and I think they are stonewalling, but for the sake of discussion, if they weren't stonewalling, in federal court, there's a way where you can delay discovery, and it wouldn't be illegitimate. So that's kind of where discovery is. But the FOIA reply kind of puts their delayed discovery or their impediment to discovery and their acts of concealment puts it into a different light. So I opposed the motions to dismiss, all three, and the motion to compel arbitration, and cited, when I filed my oppositions, I cited both the matter in the March 16th FAQ, and then I subsequently filed a document citing the information and my analysis of the information that was contained in the reply to the 3/30/23 dated FOIA reply. I then thought, after kind of looking at it, even though it was set forth in various documents, I thought for ease of the court and the judge to read it, that I would amend the complaint and put it in the complaint as new allegations based upon the new matter that was discovered. And so, because there's a meet and confer requirement in the jurisdiction I'm in, on April 4th, I sent a communication to all counsel. They had already seen the FAQ, the FOIA reply, and my analysis of it, because I had sent it to them. And I asked them to stipulate to the filing of my third amended complaint. I had to ask because that's what the local rule requires. But I would ask anyway, because if they said yes, it would save me work. So I gave them until the 8th of April to respond. Although technically, if there was any real chance that they would say yes, which really was not, it needs to be 1 week per the local rule. But as it turned out, on April 6th, I got notice that the court had now taken the motions to dismiss and oppositions, etc., under submission. So the court actually now was reviewing it and was at some future point going to make a decision, and that the hearing dates on April 17th were now off calendar. And in federal court, often in the hearing dates don't happen. It's shockingly, it's not a requirement. And oddly, in state court, hearings almost always happen. So the fact that the hearing went off on the 17th is not really of significance. I kind of expected that. I also knew that the defendants would not stipulate to the filing of my third amended complaint, but I was really concerned after receiving the notice from the court on 4/6 that they had started the review, and I didn't want the court to waste its time and get pissed about considering all the motions and all the oppositions when the amended complaint might take care of all those issues. I didn't want the judge to rule without being fully cognizant of everything contained in the new paragraphs 14A through 14P. So earlier than I would have liked, but not wanting to risk it, on the 7th, I filed the motion to amend a new proposed third amended complaint so I could make sure that it was before the court before they ruled on any motions to dismiss. As it turned out, and not surprisingly, later that day, and I understood the risk, the court returned the filings and basically asserted that I had to wait the full 7 days after the meet and confer to file. Not a surprise, but at least, and this I thought was the most important thing, the court is aware of the third amended complaint and the contents, and is now aware of the new paragraphs 14A and through 14P prior to making any ruling. And anyway, on the 12th, which is next Wednesday, I'll refile everything again, and it will be before the court before the 17th. But I didn't really want to risk just that risk that the court would act without seeing that and seeing the totality of the allegations that were raised, especially in the FOIA reply. So the court is now aware of the first and second of investigations in 2021 and 2022, and FINRA and the SEC's suppression of same. It's referenced in the FOIA reply. They're aware of the blue sheets, that the blue sheets were pulled before the corporate action notices. The corporate action notices are the responsibility of FINRA, as they acknowledge. And more importantly, that defendants concocted an unrelated plan having nothing to do with the settlement issues. And if you recall, that was the claim that FINRA asserted was the basis, to not trade MMTLP after 12/8, and that plan was concocted around December 2nd. And as it turned out, I bought stock, MMTLP stock, after that date. But it was clearly that this plan was clearly concocted long before any corporate action notice was prepared. So the court is now aware of that. The court is also aware of the fact that the highest officials at both FINRA and the SEC were both aware of this and did nothing on multiple occasions. They're aware of the short trading on 12/8 and that it's only explained. The only logical explanation is an exclusive agreement amongst the defendants and clearly they were all tipped off, because if they weren't tipped off, then the shorting on the 8th, as I've reiterated about 90 times, absolutely makes no sense. They're also aware, the court is now aware of the short shares that exist in NextBridge, and it's also aware, for example, that there's evidence that FINRA and the defendants knew that at NextBridge, or excuse me, that MMTLP would trade at 100x minimum on the 9th, and that obviously played a role in the decision making, or confirmation of their decision making not to trade. That was concocted. I like that word, concocted on at latest on 12/2. So whatever nonsense they led us to believe, they knew to the contrary and suppressed it. So all that now is before the court, or the court is aware of it, and officially all the pleadings will be before them again next week. So that's up to date. You have it up to date, and after my next filings, I will bring you up to date as I do. So separate and apart, and kind of, it might be humorous in some way, being that it seems to be the course of conduct for all the brokers to act outside appropriate practice, and being that they constantly allude to the fact that arbitration is the correct and only manner to resolve disputes involving broker-dealers, I have demanded arbitration of my fidelity account, the totality of it. So the account that has the MMTLP shares, separate and apart from that, as to all other securities and all trades that were made in that account, I have requested arbitration, because if in fact this is the course of conduct as to MMTLP, I presume this is how they handled everything. And to the extent, if I would have known that before opening the account, I never would have opened up the account. And so any losses that were occasioned during that time period, I'm going after them. Same thing about MMAT. I didn't have my account at Fidelity did not have MMAT shares. I bought them in another account with another institution. But the actions of Fidelity seem to have impacted my MMAT shares with regard to their actions as to MMTLP. So I asked them to arbitrate that, since that's what they want to do. And as of now, they have not accepted. But if they don't accept, then they force me to file an action. So if that occurs, of course, I will keep you all apprised. Can't believe they don't want to arbitrate these. Shocking. As an aside, and I'm not going to discuss it until the time comes, I do have a blow up the system strategy that is legitimate and assertive, but I'm kind of holding that in abeyance to see what happens, because it's large. It will require a very coordinated effort, but it's very doable. But I want to see if we can resolve it without me suggesting this. It may not be earth-shattering, by the way, but I think it would be an effective way of basically shaping a general strike. Let's say it that way. So that brings you up to date. Be well. Have a good day with your families. I'll continue to let you know what's happening, at least the best I can. I'll continue to fight for what we deserve as a community and as citizens of this country. Be well. Have a great weekend, and see you again soon.